Hello, everyone. We're going to continue with Trump v. Barbara. The law of domicile is essential to understanding the citizenship provisions of the Civil Rights Act and the 14th Amendment, so I briefly explain the relevant parts of the law of domicile here. Domicile meant legal home. The most common definition of domicile was residence with the intent to permanently remain. See a story on conflict of laws, residence, and the intention of making it the home of the party. A person's residence was the place where he lived. He had the intent to permanently remain in that place if he planned to stay there indefinitely. A person who was not domiciled in a place simply because he was temporarily present or born there. A person's presence in a place was merely prima facie evidence that he was domiciled there. Because a person's temporary visit to a place did not change his domicile, persons who were temporarily present in a place were regarded by the law not as subjects but as strangers. See Reddington versus Overseers of Tewksbury. The place of the birth of a legitimate child is prima facie the place of his settlement. A child took on the domicile of his parents. Because any person incapable of establishing his own domicile had the domicile of that person on whom he depends for support, it followed that generally minor children who had the settlement of their fathers. So if a child was born to foreigners who did not permanently reside there, the child was not domiciled here. Or who did not permanently reside here, the child was not domiciled here. Finally, each person had one and only one domicile. Every person must have a domicile somewhere, and every person can have only one domicile. See outlines of an international code by field. The supposition that a man can have two domiciles would lead to the absurdest consequences. A person can reside and intend to permanently remain in only one place at a time, and no person, according to the law of nations, is without a domicile. So, if someone did not intend to remain where he was at the moment, the law ascribed that person his last such place as his domicile. Because a person could have only one domicile, domicile was a natural criterion for citizenship. In the 19th century, dual citizenship was considered highly undesirable, if not a contradiction in terms. The general view was that no one can have two countries. Dual citizenship led to a number of foreign policy concerns, such as conflicting claims on the dual citizen during a war. Therefore, the United States did not recognize a double allegiance. Instead, under our law, a citizen was bound to be true and faithful alone to our government. See as Savorgnan of the United States. The United States has long recognized the general undesirability of dual allegiances. Because each person had one and only one domicile, domicile-based citizenship avoided the problems attendant to dual citizenship. The principle that citizenship followed domicile also made it more likely that citizens would be attached to their country. As Alexander Hamilton envisioned it, the citizenry were the people who would join together against any threat, a large body of citizens who stand ready to defend their own rights and those of their fellow citizens. As Frederick Douglass saw it, citizenship belonged to those who fought and bled in the same battles, and gained and gloried in the same victories. And as this court put it, it is to the citizen that the country must look for its safety. The dignity and glory of American citizenship. Citing United States v. Gettysburg Electric Company, the dignity and glory of American citizenship belongs to people who have a meaningful tie to this country. A domiciliary had, by definition, the sort of permanent attachment to a place that befitted him to citizenship. A temporary visitor whose homeland was somewhere else, although he had legal rights and was entitled to dignified treatment, lacked the ties to this country that would make him fit for citizenship. He therefore was generally not eligible for naturalization, and his children were likewise not natural citizens of their birthplace. Once a person became domiciled in a place, he was considered no longer subject to any foreign power. A person was subject to the government of where he was domiciled. When a person traveled abroad, he remained subject to the power of his home nation, much like an American who travels abroad today remains subject to the power of this government. As this court explained, if a person goes into a foreign country on a temporary visit, he remains subject to the power of his home country. When a person moved to a country permanently, by contrast, he was no longer subject to the power of the country from which he originated. Those who resided in a new nation from a permanent cause became subject to the new nation. American legal authorities described a person as subject to the jurisdiction of the government of his domicile. Then, as now, governments exercised different types of authority over temporary visitors and permanent residents. A government does not apply the same laws in all matters to persons who are only temporarily resident, as it applies to persons who are permanently resident within its territory. So while a government applied, among other things, its ordinary criminal laws to temporary visitors, it had a wide range of further powers only with respect to persons domiciled within it. For that reason, when someone was present in a territory but had a domicile elsewhere, although he was still amenable to the laws of the host government, that government would describe him as not subject to our jurisdiction. In contrast, when a party made his habitual and usual domicile in a place, he became, in 1860 parlance, subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile because of the legal relationships that followed from domicile. The fact of domicile was one of the highest importance to a person. It was said that domicile determines a person's civil and political rights and privileges, duties and obligations. It fixes his allegiance. It determines his belligerent and neutral character in times of war. It regulates his personal and social relations whilst he lives, and it furnishes the rule for the disposal of his property when he dies. The legal relationships that followed from domicile, which collectively made a person subject to the jurisdiction of the government of his domicile, could be grouped into four categories. First, domicile determined which government had the power to declare the law as to an individual's most important personal affairs. The law governing personal affairs included the laws of marriage and divorce, which followed a couple's domicile. It included laws governing the succession of a person's estate, which was distributed according to the law of distribution of the place of his domicile. And it included laws governing a person's age of majority, his capacity to contract, his right to sue, and his rights with respect to movable property. Jurisdiction over these personal affairs had exclusive operation given to it only with respect to persons domiciled. Mere territorial presence was not enough. Second, domicile determined which government had plenary jurisdiction over a person to regulate his actions anywhere. The law governing domiciliaries, unlike the law governing temporary visitors, had effect given to it beyond the limits of the territory. And as now, a government could exercise personal jurisdiction over domiciliaries while the domiciliaries were abroad and for their conduct abroad. In personam judgment has extraterritorial force when rendered by government where domiciled. Quoting Goodyear Dunlop Tires Operations v. Brown. Third, domicile determined which government had the power to impose personal taxes on a person. The power to impose personal and income taxes depended on the party's domicile. A sovereign could tax the property in its territory belonging to anyone, but it could impose personal taxes such as a capitation tax only on persons domiciled within it. A person not domiciled is not within the jurisdiction of the assessors. He was not liable to taxation in the city for his income, and personal property, because his residence and domicile was not in the city. See Inria Hood's estate, describing the rule of great antiquity and of high obligation that taxation follows the domicile. So while transient travelers were not liable for ordinary governmental or municipal taxes, such taxes could be collected from domiciled aliens. A non-domiciliary could recover taxes as improperly collected because he was, regardless of his territorial presence, not subject to the jurisdiction of the taxing authority. Fourth, domicile determined which government owed a person protection when he went abroad, as this court explained. The American citizen who goes into a foreign country, although he owes a local and temporary allegiance to that country, is yet, if he performs no other act, changing his condition, entitled to the protection of our government. So, before the Civil War, the federal government intervened to protect Americans abroad based on their domicile. A non-naturalized domiciliary abroad was entitled to protection as an American citizen. The Department of State throughout the 19th century repeatedly confirmed the right of persons domiciled in the United States but not naturalized therein to maintain internationally their status of domicile and to claim protection from this government in the maintenance of such status. This protection abroad corresponded to the primary allegiance that the domiciliary owed his home government. When a person went abroad for the first time, his own state still possessed a right to his allegiance. He continued under the obligations of his home allegiance, and his children, though born in a foreign country, were not born under foreign allegiance. Although he owed a partial and temporary allegiance to his host nation, he was excused from military service and other obligations is distinctively associated with natural allegiance because he owed a prior and more binding allegiance to his own sovereign. Domicile was for that reason typically a prerequisite to, among other things, compulsory service in the militia. And although America, more than other nations, supported the right to change that allegiance, it held that doing so required a change of domicile. When Dred Scott sued for his freedom, he claimed to be a citizen of Missouri, the state of his domicile. Scott, a black man held in slavery, sued in a federal court, which could hear the case only if it was between citizens of different states. Scott argued that he was a citizen of Missouri and that the defendant, Sanford, was a citizen of New York. Scott, though, was not born in Missouri. He was born in Virginia, but domiciled in Missouri. He alleged that he was a Missouri citizen because he and his family were brought there in 1838, where they have ever since resided. He argued that the term citizen described persons identified with the communities where they reside. In response to the argument that blacks could not vote and therefore were not citizens, Scott explained that a person need not have acquired all these rights. It is only necessary that he should have acquired a domicile to enable him to sue as a citizen. Citizenship, Scott argued, in terms that would have been familiar at the time, means nothing but residence. Nobody disagreed with the premise that Scott was domiciled in Missouri. Black slaves and freedmen alike were unambiguously Americans. They were not foreigners. They were not aliens. They owed no foreign allegiance. It was the dissimilarity of American blacks to foreigners that Frederick Douglass emphasized in his call for recognizing the citizenship of blacks. We address you not as aliens nor as exiles, humbly asking to be permitted to dwell among you in peace. Instead, we are Americans. So speaking the same language and being of the same religion, worshiping the same God, owing our redemption to the same Savior, and learning our duties from the same Bible, Douglass reasoned, we shall not be treated as barbarians. American blacks were liable to perform all the duties and support all the obligations of citizens. They were domiciled in the United States, whether in slavery or freedom. Dred Scott was therefore a citizen of Missouri. This court disagreed. It held that Scott was not a citizen of Missouri and therefore could not sue as a citizen because of his race. According to the court, blacks could not be citizens because they were considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. As a result, the court said, blacks were denied the basic privileges of citizenship, including the right to keep and carry arms wherever they went, and to exercise the full liberty of speech in public and in private. They could not sue in federal court as state citizens. Justice McLean and Curtis dissented. Justice McLean would have ruled that Scott was a citizen of Missouri because he had a permanent domicile in the state. As he stated the law of citizenship, being a freedman and having his domicile in a state different from that of the defendant, he is a citizen. Likewise, Justice Curtis took the position, common at the time, that national citizenship was simply based on state citizenship. He said that birthplace alone is not sufficient to be a national citizen, but that a person must be both born here and a citizen of a state. Those persons born within the several states who are citizens of the state are thereby citizens of the United States. State citizenship, of course, was based on domicile. Justice Curtis thus agreed that Scott was a citizen of Missouri. Critics of the Dred Scott decision consistently took the position that citizenship should be based on birth and domicile regardless of race. Domicile, after all, was colorblind. In the words of Representative John Bingham of Ohio, soon to become a central figure in the crafting of the 14th Amendment, all free persons born and domiciled within the jurisdiction of the United States are citizens of the United States from birth. Blacks such as Dred Scott called America home, so they were citizens despite having been subordinated based on their race. As Representative Schellenbarger would explain, persons of African descent whose ancestors were slaves were entitled to citizenship because they were domiciled in our own country and continued here to reside. Likewise, Representative Philemon Bliss condemned Dred Scott and explained that all persons born here were citizens regardless of their race, except for children born to temporary sojourners. Chief among the critics of Dred Scott was Abraham Lincoln. Soon after the court released the decision, Lincoln declared that the Dred Scott decision is erroneous and did obvious violence to the plain, unmistakable language of the Declaration of Independence. The case exacerbated national division over the issue of slavery and contributed to Lincoln's election as president. Lincoln vowed not to acquiesce in it as a precedent, but instead to do what we can to have it overruled. During the Civil War, Union officials continued to define citizenship based on birth and domicile. Lincoln's Attorney General Edward Bates wrote that the place of birth was prima facie evidence of citizenship, a rule that corresponded with the familiar rule that place of birth was prima facie evidence of domicile. Every citizen of the United States is a citizen of the particular state in which he is domiciled. The Lincoln administration deemed persons citizens if they were born and domiciled in the United States. Mrs. Prado was born in New Jersey and no doubt at her father's domicile, so she was therefore born a citizen of the United States. Quoting the Attorney General in 1862, Congress's discussion of who could be subject to a wartime conscription law focused on the distinction between temporary sojourners and those who settled here, with the intention of making their home here. Only the latter were fully and completely subject to the law. For the purposes of conscription, children of foreigners born here were American citizens if permanently domiciled in the U.S., and could avoid conscription if their parents had not established a long-term residence in the United States. Even at a memorial service for Lincoln, prominent statesman George Bancroft confirmed that everyone born on American soil, with few exceptions of the children of travelers and transient residents, owes it a primary allegiance. After the Civil War, Congress vindicated Lincoln's vow to overrule Dred Scott, first with the Civil Rights Act, then with the Citizenship Clause of the 14th Amendment. Congress enacted the Civil Rights Act of 1866 to repudiate Dred Scott. The Civil Rights Act of 1866 confirmed that former slaves were citizens, but it did not extend citizenship to foreign temporary visitors or Indians who were still within their tribes. The Civil Rights Act guaranteed citizenship only to persons born here and not subject to any foreign power. In full, the citizenship provision of the Civil Rights Act, which formed the basis for the Citizenship Clause at issue in this case, stated that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Temporary visitors domiciled in a foreign country remained subject to a foreign power. The Civil Rights Act therefore intentionally excluded children of foreign temporary visitors. The congressional debates were clarifying on this score. When Senator Trumbull introduced the Civil Rights Act's citizenship provision, he stated that the language excluded persons temporarily resident in the United States, whom we would have no right to make citizens. He had considered limiting the Civil Rights Act's citizenship provision to persons owing allegiance to the United States, but he abandoned that terminology because temporary visitors owed a partial allegiance to the United States, and he wanted to make clear that the act excluded them. Likewise, when Representative James Wilson spoke in support of the act in the House, he explained that every person born in the United States is a natural-born citizen, except, it may be, children born on our soil to temporary sojourners. Others confirmed that the Civil Rights Act excluded the children of temporary visitors. Representative Bingham described the Civil Rights Act as simply declaratory of pre-existing law, which he had already explained required that a citizen be both born and domiciled in the United States. Bingham understood the act to grant citizenship only to children of parents not owing allegiance to any foreign sovereignty. Representative Martin Thayer agreed that the act required that a person not owe allegiance to a foreign power. Of course, temporary visitors and their children owed allegiance to their home country. Unsurprisingly, then, the public interpreted the act to guarantee citizenship to all persons born in the United States, except those subject to foreign governments, a class which included those born to foreign parents temporarily sojourning in this country. The Civil Rights Act also excluded from citizenship Indians not taxed. This provision was intended to exclude Indians in tribes, but to This provision was intended to exclude Indians and tribes, but to recognize the citizenship of Indians who had left those tribes and joined the body politic. In Senator Trumbull's words, it excluded Indians who belonged to the Indian tribes. But it included Indians who were no longer connected with their tribes, and instead lived and earned a livelihood in the white settlements. Tribal Indians were considered virtually as foreigners, but whenever they were separated from those tribes and came within the jurisdiction of the United States so as to be counted, they were citizens of the United States. Like temporary visitors, tribal Indians were not completely subject to the jurisdiction of the United States. The United States did not have the right to impose personal taxes on them, hence Indians not taxed. Their personal affairs remained subject to the jurisdiction of their tribal nation. The right of self-government was secured to each tribe with jurisdiction over all persons and property within its limits, subject to certain exceptions, founded on principles somewhat analogous to the international laws among civilized nations. The United States did not interfere with the disposition or dissent or tenure of their property, as between themselves, or approve their wills, or subject them to the laws of marriage and divorce, or subject them to the laws of the United States against high treason. Tribal Indians did not owe the United States primary allegiance and did not receive from it complete protection. Here, legal status of Native Americans in the latter half of the 19th century. Native Americans were comparable to foreigners because they did not fall completely under U.S. jurisdiction. Indians in tribes were not covered by the Civil Rights Act's exclusion of persons subject to any foreign power, because Indian tribes were not foreign. They were domestic dependent nations. Thus, to preserve the status quo that tribal Indians were not citizens, Congress used the clause not subject to any foreign power, excluding Indians not taxed. Although the Civil Rights Act by its terms overruled Dred Scott, the Reconstruction Congress could not be sure that it would endure. Some questioned whether Congress had the constitutional power to enact the Civil Rights Act and thus feared that a hostile court might neuter it. Others worried that as soon as the Democrats came into power, they would repeal the act. Thus, when it passed the Civil Rights Act, the Reconstruction Congress was already drafting the 14th Amendment. 2 months later, Congress would formally propose the Citizenship Clause of the 14th Amendment to the states. The states ratified the amendment in 1868. The Citizenship Clause of the 14th Amendment constitutionalized the Civil Rights Act's citizenship provision. The main object of the clause was to settle the citizenship of freed slaves. In full, the Citizenship Clause provided, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The language, all agreed, unambiguously overruled this court's contrary holding in Dred Scott v. Sanford, that the Constitution did not recognize Black Americans as citizens of the United States or their own state. The Citizenship Clause forever closed the door on Dred Scott and constitutionalized the Civil Rights Act of 1866 by foreclosing a racial criterion for citizenship. The Citizenship Clause did not change the Civil Rights Act's rule. The clause and the act were passed by the same Congress during the same session. Senator Howard, who proposed the Citizenship Clause, believed that it hardly warranted discussion because Congress had just enacted the same rule in the Civil Rights Act. The Senate had so fully discussed the question of citizenship as not to need any further elucidation. He also stated that the Citizenship Clause is simply declaratory of what I regard as the law of the land already. Senator Trumbull, who had introduced the Civil Rights Act's citizenship provision, confirmed that the object to be arrived at is the same. Senator Johnson, who had no doubt that all that this amendment provides is that all persons born in the United States and not subject to some foreign power are citizens of the United States, To be a citizen, Senator Howard said, meant to be not a subject of a foreign power. The phrase subject to the jurisdiction was a familiar way to describe the relation of a domiciliary to his home nation. Lawyers in America would have known that a person was subject to the jurisdiction of the place of his domicile. Congressman confirmed that the clause should not be construed to refer to the bare territorial power that a sovereign exercises over all persons in its territory. I understand the words here. Subject to the jurisdiction of the United States, Senator Reverdy Williams said, to mean fully and completely subject to the jurisdiction of the United States. The word jurisdiction, as here employed, Senator Howard explained, ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. The Citizenship Clause, Senator Trumbull agreed, means subject to the complete jurisdiction thereof. So, although in one sense all persons born within the geographical limits of the United States are subject to the jurisdiction of the United States, Senator Williams explained some were not covered by the Citizenship Clause because they are not subject to the jurisdiction of the United States in every sense. Each of these descriptions precluded applying the Citizenship Clause to the children of temporary visitors, who, unlike children domiciled here, were not subject to the jurisdiction of the United States in every sense. It was on this basis that Congress believed that the clause fixed in place the rule of the Civil Rights Act. Senator Trumbull stated that the Citizenship Clause, like the Civil Rights Act, would still exclude all persons subject to a foreign power. What do you mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. Senator Howard agreed that the Citizenship Clause would not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. And shortly before the Citizenship Clause was introduced, Senator William Fessenden, a supporter of the amendment, explained that persons may be born in the United States and not be citizens of the United States. Then gave the example of a person who is born here of parents from abroad temporarily in this country. The Citizenship Clause, just like the Civil Rights Act, also excluded from citizenship the children of tribal Indians, meaning Indians whose tribes retained sovereign authority over them. Certainly, Senator Howard said, gentlemen cannot contend that an Indian belonging to a tribe, although born within the limits of a state, is subject to this full and complete jurisdiction. As Senator Trumbull saw it, tribal Indians were excluded because they, like temporary visitors, retained a primary allegiance to, and therefore were subject to, their tribal nation. It cannot be said of any Indian who owes allegiance, partial allegiance, if you please, to some other government that he is subject to the jurisdiction of the United States. He concluded, it is only those persons who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens. Congress was satisfied that its language accomplished that result with the phrase subject to the jurisdiction thereof. As Senator Williams explained, it would not agree to this proposed constitutional amendment if I suppose it made Indians not taxed citizens of the United States. But I am satisfied that giving to the amendment a fair and reasonable construction, it does not. The Citizenship Clause used different wording from the Civil Rights Act only to resolve an uncertainty that had arisen out of the Act's Indians not taxed language. Senator Trumbull explained that the category of Indians not taxed was an attempted proxy for the Indians over whom the United States lacked complete jurisdiction. The Civil Rights Act was supposed to designate a class of persons who were not a part of our population, so it was supposed to exclude tribal Indians while including Indians who come within the jurisdiction of the United States. The former could not be taxed, in the sense of personal taxes. But the phrase excluding Indians not taxed, Trumbull realized, could be misunderstood to encompass Indians who had left their tribal community and permanently settled outside of it, but were not taxed for other reasons, such as because they were not possessed of wealth. Similarly, making citizenship depend on taxation could allow states to manipulate citizenship eligibility by changing their tax practices. The phrase subject to the jurisdiction solved the problem because it avoided excluding from citizenship the children of non-tribal Indians who, for whatever reason, were not taxed. Tribal Indians were not in any sense subject to the complete jurisdiction of the United States. Like temporary visitors, tribal Indians were not subject to our jurisdiction in the sense of owing allegiance solely to the United States. Their internal affairs, including marriages, family matters, intest- intestacy, and payments of personal taxes, were regulated by their tribes. Thus, members of Congress understood the 14th Amendment's language to be more precisely describing, not substantively altering, the set of individuals excluded from birthright citizenship by the Civil Rights Act. With respect to temporary visitors from foreign nations, the phrase was believed to accomplish the same object as the Civil Rights Act's exclusion of those subject to a foreign power. Children born to temporary visitors owed allegiance to another government, the country of their domicile, so they were not subject to the jurisdiction of the United States. The Citizenship Clause simply states, in positive terms, subject to the jurisdiction thereof, what the Act stated in negative terms, not subject to any foreign power. The evidence from the decades following ratification confirms that the Citizenship Clause was understood to exclude the children of temporary visitors. There was frequently expressed, enduring, and widespread agreement from the Reconstruction Congress through the end of the 19th century, and even into the 20th, that the Citizenship Clause did not guarantee citizenship to persons not domiciled here. The executive branch, Congress, courts, states, lawyers, scholars, and commentators generally shared this understanding. The executive branch understood the Citizenship Clause to exclude the children of temporary visitors. In 1873, President Grant's Attorney General George Williams interpreted it to apply only to persons over whom the United States had complete jurisdiction. The word jurisdiction must be understood to mean absolute or complete jurisdiction, such as the United States had over its citizens before the adoption of this amendment. It therefore excluded aliens over whom the United States had only a limited jurisdiction, even if they were born here. Across administrations, the executive branch took the same position. A child born on American soil was not an American citizen when he was domiciled in a foreign country. By virtue of his foreign domicile, he was on his birth subject to a foreign power and not subject to the jurisdiction of the United States. A child born in this country to a foreign father, when taken by his father abroad, acquires the father's domicile and nationality. These statements were not mere abstract positions, but the executive branch's operating rule of decision for decades. When the children of temporary visitors born on American soil claimed to be citizens based on the Citizenship Clause, the executive branch repeatedly denied their claims to citizenship. Joseph Speck was denied citizenship after being born in the United States to parents domiciled in Switzerland. In 1878, Speck claimed to be a citizen after his father returned with him to Switzerland. President Hayes, acting Secretary of State Frederick Seward, rejected his claim. Although Speck may have been able to claim citizenship had he been domiciled in the United States, Seward denied his claim because his status as well as his domicile, according to the well-understood principles of international and municipal law, follows that of the father until the boy attains his majority. Ludwig Hosding was denied citizenship after being born in the United States to parents domiciled in Saxony. Hosding's parents were Saxon subjects temporarily in the United States. President Cleveland's Secretary of State Frederick Frelinghuysen explained in 1885 that Hosding was not constitutionally entitled to citizenship. Because Hosding's parents were not domiciled here, he remained subject to any foreign power. Therefore, his attempt to assert citizenship on the ground of birth in the United States was untenable. Richard Greiser was denied citizenship after being born in the United States to parents domiciled in Germany. He was born in 1867 in the state of Ohio. His father was domiciled in Germany. According to President Cleveland's Secretary of State Thomas Bayard in 1885, Greiser therefore was on his birth subject to a foreign power and not subject to the jurisdiction of the United States. He was not therefore under the statute and the Constitution a citizen of the United States by birth. The State Department thus denied Greiser's claim to citizenship. Frederick de Bury was denied citizenship after being born in the United States to parents domiciled in Austria. When de Bury sought protection as an American citizen in 1886, after returning to Europe, Secretary Bayard denied his claim to citizenship, although de Bury was born in the city of New York. Secretary Baird explained his parents were temporarily resident and returned to Europe a few years later. He then remained in Europe, showing that an Austrian domicile was chosen. Secretary Baird concluded that DeBoer's passport must therefore be refused. The child of a woman named Marie Devereaux was denied citizenship after being born in the United States in 1889. Devereaux was an Irish woman who arrived in New York and was promptly went to the hospital to give birth the next day. She was not yet, however, lawfully admitted to the country. Although the baby was undoubtedly born on American soil, it was not an American citizen because Devereaux had not yet been lawfully admitted. President Harrison's administration denied the baby citizenship. I am therefore of the opinion that the child in controversy, born during the temporary removal of the mother from the importing vessel to a lying-in hospital for her own comfort, pending further examination as to whether she belongs to the prohibited class of immigrants, did not become, by reason of its birth, under such circumstances, an American citizen. These children were not born to diplomats. They were not part of invading armies or Indian tribes. They were simply foreigners, born on American soil but not domiciled here, and they were all denied citizenship under the Citizenship Clause by those in a better position to know its original meaning than we are today. Even the most expansive executive interpretation of the Citizenship Clause ultimately denied citizenship to a child born here but domiciled abroad. When Francois Heinrich, born of parents who ultimately returned to their native Austria, claimed to be an American citizen, President Grant's executive branch did say that he was originally clothed with American nationality, but it then promptly denied Heinrich's claim to American citizenship. Heinrich was instead, despite being born in the United States, a citizen of Austria, where he was domiciled. Francois H. Heinrich should be held by the United States to be an Austrian subject and treated as such. He is not an American citizen. A letter from Secretary of State Fish to Baron Lederer. Congress understood the Citizenship Clause to exclude the children of temporary visitors. Just 2 years after the 14th Amendment was ratified, Congress passed the Enforcement Act of 1870. The act implemented the Citizenship Clause with the same language that the Civil Rights Act had used, limiting the right to citizenship to persons born here and not subject to any foreign power. See the Enforcement Act of 1870, Reenacting Act of April 9th, 1866. The 1870 Act thus incorporated language that expressly excluded the children of temporary foreign visitors who were subject to the power of the foreign countries in which they were domiciled. If the Citizenship Clause included the children of temporary visitors who clearly fall outside the reach of the Enforcement Act, then the Reconstruction Congress would have violated its own Citizenship Clause in an act designed to enforce it. The parties point to no one who suggested that the 1870 Act was unconstitutional. This court long agreed that the Citizenship Clause did not apply to persons born here to children of temporary visitors. Just 5 years after the Citizenship Clause was ratified, this court explained that the phrase subject to the jurisdiction excluded persons not domiciled here. The phrase subject to its jurisdiction, the court explained, was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. Then, in Elk, the court again interpreted the clause to require complete jurisdiction, not just bare territorial authority. The court held that to satisfy the Citizenship Clause, a person must not only be born within the territorial limits of the United States, but must be completely subject to the United States political jurisdiction at birth. The Citizenship Clause's evident meaning, this court said, is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to its political jurisdiction and owing it direct and immediate allegiance. The Citizenship Clause thus granted citizenship at birth only to persons who owed no allegiance to any alien power. Of course, the children of temporary visitors were not completely subject to the United States' political jurisdiction, did not owe the United States direct and immediate allegiance, and did owe allegiance to an alien power. Justice Harlan dissented in Elk, but he agreed that the Citizenship Clause referred to the same complete jurisdiction. He dissented only because he thought that someone born in the territorial United States could become a citizen even if he became subject to its complete jurisdiction later in life. On Justice Harlan's view, which was not uncommon at the time, the Citizenship Clause did not require that the person be born while subject to the complete jurisdiction of the United States. Instead, a person could be born in the United States while not subject to its jurisdiction, as John Elk was, because he was a member of an Indian tribe at birth, but become subject to its jurisdiction later, as Elk did by abandoning his tribe. On Justice Harlan's view, following the law of domicile, persons became subject to the jurisdiction of the United States by becoming bona fide residents of states and subject to taxation there. See here, explaining that one becomes subject to the complete jurisdiction of the United States by residence in one of the states. Every justice in Elk thus agreed that the Citizenship Clause did not refer to bare territorial authority. The most celebrated 14th Amendment opinion is Justice Harlan's dissent in Plessy v. Ferguson. In that dissent, Justice Harlan disagreed with the Plessy Court's conclusion that the Constitution tolerated state-imposed segregation. Justice Harlan took the position, to be vindicated decades later, that our Constitution is colorblind and neither knows nor tolerates classes among citizens. He also took a view on whom the Citizenship Clause applied and did not apply to. According to Justice Harlan, the Citizenship Clause did not apply to persons born here who resided abroad. Instead, it gave citizenship to all born or naturalized in the United States and residing here. State officials likewise agreed that the Citizenship Clause excluded persons not domiciled here. Although the Citizenship Clause guaranteed both national and state citizenship, states excluded from citizenship children of transient aliens. Citing Political Code of California, Accord, the Codes of North Dakota, the citizens of the state are all persons born in this state and residing within it, except the children of transient aliens. The complete codes and statutes of the state of Minnesota. The citizens of the state are all persons born in this state and residing within it, except the children of transient aliens. Nobody seemed to suggest that these state laws violated the 14th Amendment. Likewise, state judicial precedent held that the Citizenship Clause included children born of foreign parents only when the parents are domiciled here. To qualify for citizenship, two facts must concur. The person must be born here, and he must be subject to the jurisdiction of the United States according to the 14th Amendment, which means, according to the Civil Rights Act, that the person born here is not subject to any foreign power. The Citizenship Clause thus accepted those born in this country of foreign parents who are temporarily traveling here. Scholars agreed as well that the Citizenship Clause required domicile. As early as 1875, Yale Law School professor William Robinson wrote that a native-born citizen was one who was born within the jurisdiction and allegiance of the United States. And to be born within the jurisdiction and allegiance of the United States, a person born within the territory of the United States of alien parents had to show that those parents were permanently domiciled within the United States. A long list of eminent 19th century legal scholars, including Thomas Cooley, Francis Wharton, Henry Campbell Black, and Justice Samuel Miller agreed. Cooley wrote that a citizen by birth must not only be born within the United States, but must also be subject to the jurisdiction thereof. And by this is meant that full and complete jurisdiction to which citizens generally are subject, and not any qualified and partial jurisdiction, such as may consist with allegiance to some other government. Francis Wharton explained that children born in the United States of parents not being here domiciled are not citizens. Citizenship Clause excluded children born in the United States to foreigners here on transient residence, such children not being by the law of nations subject to the jurisdiction of the United States. Henry Campbell Black of Black's Law Dictionary wrote, "If a stranger or traveler passing through the country or temporarily residing here has a child born here who goes out of the country with his father, such child is not a citizen of the United States, because he was not subject to its jurisdiction." By contrast, the children born within the United States of permanently resident aliens are citizens. And Justice Samuel Miller confirmed in his lectures on constitutional law that if a traveler temporarily residing in this country has a child born here which goes out of the country with its father, such child is not a citizen of the United States, because it was not subject to its jurisdiction. Scholar after scholar confirmed that domicile was required for citizenship. The words "subject to the jurisdiction thereof" excluded the children of foreigners transiently within the United States. The citizenship clause excluded the children of foreign subjects born while the latter transiently sojourned here. The children of foreigners in transient residence are not citizens, their fathers being subject to the jurisdiction less completely than Indians. And then see also a Hall International Law. In the United States, it would seem that the children of foreigners in transient residence are not citizens. The requirement of personal subjection to the jurisdiction thereof excludes children of persons passing through or temporarily residing in this country. As immigration laws became more restrictive, some adopted the view that children must be born to citizens to obtain citizenship by birth. In contesting that view, its detractors spoke in terms of domicile. Prominent jurist Henry C. Ide, for example, published an article arguing that whether the very fact of birth in our country renders one subject to the jurisdiction thereof depends on the question of domicile. The jurisdiction referred to in the amendment means political national jurisdiction and not merely the jurisdiction of our laws. One born of parents temporarily in our country is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so the elements of national jurisdiction are wanting. By contrast, I'd contended, persons domiciled but not naturalized are de facto, though not de jure, citizens of the country of their domicile, so their children should be deemed de jure as well as de facto citizens. In United States v. Wong Kim Ark, this court interpreted the citizenship clause to apply to a person born and domiciled here. The case and the arguments made in it arose out of the unique circumstances of Chinese immigration in the late 19th century. Hundreds of thousands of Chinese immigrated to the United States during this time. They were met with considerable hostility. By statute, Chinese settlers could not be naturalized. Congress then banned Chinese immigration in the Chinese Exclusion Act of 1882. Meanwhile, if a Chinese person renounced his allegiance to China, the Chinese government could behead him upon his return, sell his family as slaves, and banish his relatives. Given the era's concern with dual citizenship, this policy made it even more difficult for Chinese immigrants to fully settle in the United States. Unlike other settlers, then, the Chinese, even those who lived here and wished to remain, had no path to citizenship and no means of freeing themselves from the grasp of China. The executive branch took the view that because domicile no longer ensured full integration into the American body politic, the citizenship clause's phrase, subject to the jurisdiction, must require more than domicile. That view would entail that a child born to Chinese parents domiciled in this country was not a citizen. Instead, the executive branch sought to replace the requirement of domicile, which would make any child of domiciled Chinese immigrants a citizen, with the requirement that a person's parents already be citizens. Acting on this view, the government in 1895 denied citizenship to a man domiciled in the United States from birth. The stipulated facts were these. Wong Kim Ark was born in San Francisco in 1873, and his legal home was California. His parents were not temporary visitors. They were not illegal aliens. Instead, Wong's parents had done everything within their power to express their desire and intent to become Americans. They came to settle in America. After Wong traveled to China in 1890, he returned and was admitted to the United States as a citizen. But after his second trip to China in 1894, the American customs collector denied him permission to re-enter. The government claimed, for the first time, that Wong was not a citizen. This court's decision in Wong Kim Ark concerned only persons already domiciled in the United States. As stated in the government's brief, the question presented by this appeal was, is a person born within the United States of alien parents domiciled therein a citizen thereof by the fact of his birth? The government agreed that Wong was born and domiciled in the United States. In fact, the thrust of the government's opening brief was that birth and domicile were insufficient. The government lamented the mistakes made and the misunderstanding arising from failing to distinguish between nationality and domicile. it disapproved of the decisions of some of our attorneys general and secretaries of state for their error of failing to distinguish between nationality and domicile. It acknowledged that state citizenship was based on domicile, but argued that a different rule should govern national citizenship to preserve the distinction between state and national sovereignty. The Constitution does not countenance, the government argued, making domicile an element of nationality. The court was not persuaded and ruled that Wang, born in the United States to parents domiciled here, was a citizen. The court found it so important that Wang and his parents were domiciled in the United States at the time of his birth that it gratuitously insisted upon that fact throughout its opinion. The court's introductory paragraph stated 7 different ways that Wang was domiciled in the United States. He was born to parents who were, at the time of his birth, domiciled residents of the United States. His parents were enjoying a permanent domicile and residence therein at San Francisco. His parents continued to reside and remain in the United States. He, ever since his birth, has had but one residence, to wit, in California within the United States. He had there resided. He never lost or changed that residence, and he never gained or acquired another residence. 2 paragraphs later, the court confirmed that its decision was limited to persons born and domiciled in the United States. The question presented by the record is whether a child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China but have a permanent domicile and residence in the United States becomes, at the time of his birth, a citizen of the United States. Then, if that were not enough, the court reiterated the same limits to its opinion in its final paragraph. This case presented for determination the single question stated at the beginning of this opinion, namely whether a child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, becomes, at the time of his birth, a citizen of the United States. The opinion itself was filled with meandering dicta. The court's interpretation of the Citizenship Clause evolved over the course of the opinion before landing on an interpretation that limited citizenship at birth to persons domiciled here. At first, the opinion stated that the rule of American citizenship was the feudal principle of birth on the soil with only 2 exceptions. 1. The child of an ambassador or other diplomatic agent of a foreign state, and 2. The child of an alien enemy in hostile occupation. Then, after considering more evidence and arguments, the opinion reformulated the rule to include a 3rd exception. 1. Children of members of the Indian tribes. 2. Children born of alien enemies in hostile occupation. And 3. Children of diplomatic representatives of a foreign state. Then, after discussing more considerations and authorities, the opinion reformulated the rule with at least 5 exceptions and a residence requirement. All children here born of resident aliens, with the exceptions or qualifications of 1. Children of foreign sovereigns, 2. Children of foreign ministers, 3. Children born on foreign public ships, 4. Children of enemies within and during a hostile occupation of part of our territory, and 5. Children of members of the Indian tribes owing direct allegiance to their several tribes. Then the court concluded by reiterating an explicit domicile requirement. Outside of these 5 categories, the Citizenship Clause covers all other persons of whatever race or color domiciled within the United States. So although these various statements are both dicta and irreconcilable, as is much of the opinion's reasoning, the court's most complete rule statement was limited to persons like Wang, born and domiciled in the United States. Chief Justice Fuller's dissent, joined by Justice Harlan, did not accept the government's primary theory that, to qualify for birthright citizenship, a child born in this country must also be born to citizen parents. Such a position, after all, was in tension with Justice Harlan's twice stated view that the Citizenship Clause turned on complete jurisdiction, or residence, 2 terms that corresponded to domicile. Chief Justice Fuller's dissent instead took the position that the Citizenship Clause recognized an essential difference between birth during temporary and birth during permanent residence. On his account, the Citizenship Clause excluded children born of aliens whose residence was merely temporary. Chief Justice Fuller nonetheless dissented because he rejected the premise that Wang's parents were domiciled here at the time of his birth. He explained that because Chinese law purported to bind Wang's family even after they had settled here, the family cannot acquire a permanent home here, no matter what the length of their stay may be. Thus, Chief Justice Fuller and Justice Harlan dissented because, in their view, Wang and his parents were not actually domiciled in the United States at the time of his birth. Wong Kim Ark left in place the same rule that existed before. A child of a domiciliary was a citizen, but a child of a temporary visitor was not. The effect of Wong Kim Ark, a legal scholar explained shortly after it was published, is to make citizens of the United States by virtue of the 14th Amendment all persons born in the United States of alien parents permanently domiciled and residing here. As a 14th Amendment treatise published in 1901 explained, it remained the case that mere birth within American territory does not always make the child an American citizen. The Citizenship Clause excluded children of aliens born here while their parents are traveling or only temporarily resident. Wong Kim Ark was limited to alien parents not temporarily resident here, but permanently domiciled. On this understanding of Wong Kim Ark, temporary visitors' children were still excluded from citizenship. In the United States, William Edward Hall wrote 6 years after Wong Kim Ark, it would seem that the children of foreigners and transient residents are not citizens. A 1901 international law treatise explained that children born in the United States to foreigners here on transient residence are not citizens because by the law of nations they were not at the time of their birth subject to the jurisdiction of the United States. When a father has domiciled himself in the Union, John Westlake wrote in 1904, his children are citizens. But when he is in the Union for a transient purpose, his children born within it have his nationality. This understanding was widespread after Wong Kim Ark. A person born in this country of alien parents was a citizen only if those parents were domiciled. A child born in the United States is a citizen when domiciled, but not when his parents left after being temporarily resident. A child born on American soil to a stranger or traveler passing through the country was not a citizen, but a child born within the United States of permanently resident aliens was a citizen. The rule remained, in other words, that children of foreigners in transient residence were excluded from citizenship even though born in the United States. Government officials generally agreed. In 1910, a Department of Justice report explained that it has never been held and is very doubtful whether it will ever be held that the mere act of birth of a child on American soil to parents who are accidentally or temporarily in the United States operates to invest such child with all the rights of American citizenship. The Citizenship Clause did not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but that larger jurisdiction, which, though difficult to define, is well known and understood. The difference between the jurisdiction which is exercised over a visitor and that over one domiciled, which difference may be seen at a glance. Even this court described Wong Kim Ark in limited terms. It read Wong Kim Ark to apply to aliens with a permanent domicile and residence in the United States. Wong Kim Ark, in its telling, covered children born to parents permanently domiciled in the United States. Throughout this period, Congress left in place the same statutory language that it originally enacted in 1866, and then reenacted in 1870, so American citizenship was limited to persons not subject to any foreign power. All persons born in the United States and not subject to any foreign power excluding Indians not taxed are declared to be citizens of the United States. All persons born in the United States and not subject to any foreign power are declared to be citizens of the United States. The Nationality Act of 1940 replaced that language with the same language, in relevant part, as the Citizenship Clause itself. A person born in the United States and subject to the jurisdiction thereof is a citizen. Congress reenacted that provision verbatim in the 1952 Immigration and Nationality Act, INA. It remains the governing statute today. In the 20th century, the executive practice repurposed the Citizenship Clause to treat the children of temporary visitors and illegal aliens as citizens. An assistant solicitor named Richard Flournoy prominently argued that the Citizenship Clause does include the children of temporary visitors. He disagreed with a number of writers who held that in order that a person born in the United States of alien parents may have American citizenship, his parents must have been domiciled in this country at the time of his birth. Although he acknowledged that Wong Kim Ark did not directly decide the precise point, he said that the Citizenship Clause should be read to incorporate a rule that originated with the feudal system under which all persons, with certain limited exceptions, born within the fief of an overlord were held to owe fealty to him and allegiance to the sovereign. Flournoy acknowledged that some consequences of his theory were absurd. President Franklin D. Roosevelt's administration adopted the view that the Citizenship Clause applied to the children of temporary visitors. In 1995, some 127 years after the Citizenship Clause was enacted, President Clinton's Office of Legal Counsel endorsed the same view. It explained that the right to American citizenship for the children of illegal aliens and temporary visitors is fundamental to our liberty as we understand it. Many in Congress disagreed with the executive branch's view. As late as the 1990s, Senator Harry Reid sponsored bipartisan legislation to clarify that the child of an illegal alien or temporary visitor would not be a citizen of the United States or of any state solely by reason of physical presence within the United States at the moment of birth. No sane country, Senator Reid argued, would offer a reward for being an illegal immigrant. That wasn't always true. Citing that wasn't always true in the New York Times, March 31st, 2026. Others supported similar legislation. The question was not prominent in judicial opinions in the 20th century. One of the first substantial discussions arose 105 years after Wong Kim Ark, when Judge Posner treated the matter as unsettled. A constitutional amendment may be required to change the rule whereby birth in this country automatically confers U.S. citizenship, he wrote, but I doubt it, citing Oforji v. Ashcroft. The purpose of the rule was to grant citizenship to the recently freed slaves, and it would not be flouting the Constitution to put an end to the nonsense. Some took advantage of the executive branch's recent policy of granting citizenship to anyone born on American soil. The policy encouraged birth tourism, the practice of traveling here with temporary authorization solely to give birth and obtain citizenship for one's children, then returning to raise them in another country. Today, birth tourism companies reportedly collect large fees from wealthy foreigners to facilitate their trips to give birth in the United States. Senate Committee on Homeland Security and Governmental Affairs report on birth tourism in the United States. Large numbers of children are born in the United States each year to parents who are temporarily present here in order to obtain citizenship for their children. Upon taking office, President Trump issued an executive order that expressed the executive branch's interpretation of the Citizenship Clause. The Citizenship Order adopts the view that the 14th Amendment does not guarantee citizenship at birth to the children of temporary visitors and illegal aliens. Section 1 of the order interprets the scope of the Citizenship Clause. It states that someone born in the United States is not guaranteed citizenship if that person is born here to lawful temporary foreign visitors or to illegal aliens. By contrast, a person is guaranteed citizenship if he is born here to lawful permanent residents or citizens. Section 2 of the order then directs the executive branch to implement this interpretation by not issuing documents recognizing the citizenship of persons in the two excluded categories and by not accepting documents issued by state, local, or other governments purporting to recognize the citizenship of such persons. Those directives are prospective. They apply only to persons who are born within the United States after 30 days from the date of this order. Section 3 of the order directs executive officials to implement the order with appropriate regulations, policies, and guidance. The President's initiative generated a groundswell of new scholarship into the original meaning of the Citizenship Clause. A wide range of originalist scholars have concluded that the 20th century executive practice was mistaken and that the order has substantial lawful applications. Before the order went into effect or executive agencies implemented it, several district courts universally enjoined its implementation. This court partially stayed those injunctions in Trump v. Casa because they exceeded the district court's remedial authority. Several plaintiffs immediately filed new actions, and several district courts again enjoined the executive branch from implementing the order. This case arises from one of those actions. Three plaintiffs sued on behalf of a putative class. The plaintiffs who proceed under pseudonyms are each illegal aliens or lawful temporary visitors. The first plaintiff, a Honduran citizen, was expecting a baby due in October 2025. The other two plaintiffs, one Taiwanese citizen and one Brazilian citizen, did not allege that they were expecting a baby. None alleged that any of their children will be domiciled in the United States. As a right of action, plaintiffs invoked the Citizenship Clause itself, the INA, and the Administrative Procedure Act. They sued on behalf of a putative class of all children who would be ineligible for citizenship under the president's order, as well as those children's parents, and they sought to have the order declared unconstitutional and unlawful in its entirety. The district court ruled for the plaintiffs. It interpreted the Citizenship Clause to guarantee citizenship to the children of all lawful temporary visitors and illegal aliens. As to relief, the district court certified a provisional universal class under Federal Rule of Civil Procedure 23b2, which states that class actions may be maintained if the defendant has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief is appropriate respecting the class as a whole. The certified class consisted of all current and foreign persons born on or after February 20th, 2025, who fall within the two categories covered by the president's order. The district court entered a class-wide preliminary injunction prohibiting enforcement of the citizenship order against anyone in the class, meaning anyone at all. The court today affirms the district court's universal class injunction. It holds that the 14th Amendment guarantees citizenship to all children born here to lawful temporary visitors or illegal aliens. On the court's telling, the law of citizenship in the United States was fixed to an English rule that everyone born on the soil was permanently bound to serve the sovereign. This principle of permanent feudal allegiance, according to the court, was repurposed into a rule of citizenship and adopted by all of the states. The rule's universal acceptance was embodied in an 1844 state equity decision called Lynch v. Clark. The rule extended citizenship to all persons born within United States territory, except three categories: children of foreign representatives, children over whom the government lacked actual power, and children of Indians in tribes. Those three exceptions were then adopted in the Civil Rights Act and the Enforcement Act by the phrase "not subject to any foreign power," and in the Citizenship Clause by the phrase "subject to the jurisdiction thereof." This court's Wong Kim Ark opinion, 3 decades later, the court says, confirmed the same rule. Before proceeding to the merits, I briefly note three threshold impediments to the court's decision today that the court leaves unaddressed. First, the court has an independent obligation to ensure that every single recipient of class action relief has standing. But today, it affirms an injunction on behalf of a class that includes all current and future persons subject to the order indefinitely into the future. Second, the court cannot grant relief to any party without a right of action. But it grants relief here on the basis of a suit brought under the Citizenship Clause, the INA, and the APA. The Citizenship Clause and the INA's equivalent, by their terms, create no right of action. The APA authorizes suits challenging final agency action, but the plaintiffs did not allege any final agency action. Third, because respondents sought to invalidate the citizenship order in its entirety, and the district court granted facial relief, the plaintiffs bear the burden to show that all applications of the order are unlawful. Under this court's precedent, facial challenges require plaintiffs to establish that no set of circumstances exists under which the order would be valid. To prevent federal courts from invalidating the political branch's interest in effectuating policies enacted by representatives of the people, facial invalidation must remain rare and hard to win. The court's decision to hold the citizenship order facially unconstitutional, in other words, makes it unlawful for the president to enforce the order against a single person. He cannot enforce the order against a child of an alien enemy or a child of a foreign spy. He cannot even enforce the order against children who are raised in foreign countries, join foreign armies, and fight wars against the United States. The court, without considering any of these individual circumstances, holds unconstitutional the application of the citizenship order in all of them. In my view, the citizenship order is not facially unconstitutional. The order is consistent with the original meaning of the citizenship clause, at least insofar as it applies to children born to parents here lawfully or unlawfully who are not domiciled in the United States. The citizenship clause was enacted for people who were born in this country and called it home. It was enacted for freed slaves such as Dred Scott, who had a domicile here and therefore were entitled to sue as citizens. It was enacted for men such as Frederick Douglass, who demanded citizenship not as aliens nor as exiles, but as Americans. Its authors and supporters promised over and over again that it would exclude the children of persons temporarily resident here, whom we would have no right to make citizens. In Senator Trumbull's words, what do we mean by subject to the jurisdiction of the United States, not owing allegiance to anybody else? That is what it means. And for decades after ratification, it was interpreted by all three branches of government and by a wide range of legal authorities to be limited to people who were already Americans. The ordinary principles of constitutional interpretation, the ones on which this court typically relies when presented with a constitutional question such as this one, support the conclusion that the Citizenship Clause requires domicile. That conclusion is supported by the constitutional text, contemporaneous evidence, early executive practice, early legislative practice, judicial precedent, and all of the other indicators of original public meaning. The court's alternative account does not have a similar degree of support. The citizenship order is therefore, insofar as it applies to persons not domiciled here, consistent with the Citizenship Clause. It is consistent with the Citizenship Clause in its exclusion of the children of lawful temporary visitors, such as birth tourists. The exclusion of the children of lawful temporary visitors, who are, by definition, not domiciled here, was originally a matter of widespread agreement. As to them, the citizenship order does exactly what the executive branch did for most of the rest of the 19th century, what this court said that it could do, and what scholars for decades confirmed that it could do. And the order is at least facially consistent with the Citizenship Clause in its exclusion of the children of illegal aliens, because at least some such persons are not domiciled here and therefore also are not citizens. The constitutional text supports the conclusion that the Citizenship Clause requires domicile. The Citizenship Clause guarantees citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. At the time that the Citizenship Clause was adopted, the phrase subject to the jurisdiction referred to the legal relationship that a person had to the government of his domicile. That legal relationship included the government's power over the domiciliary's personal affairs, power to regulate his conduct everywhere, and power to impose personal taxes on him. It also included the reciprocal relationship of protection abroad and primary allegiance. A government lacked the powers associated with this relationship and thus lacked complete jurisdiction over temporary visitors. Temporary visitors remained subject to the jurisdiction of their home country. Hence, a person was subject to the jurisdiction of the government where he was domiciled. This interpretation accords with the contemporaneous evidence that would have informed the public meaning of the text. It is consistent with the Civil Rights Act's requirement that citizens be not subject to any foreign power. A person born in the United States to temporary visitors was subject to a foreign power, namely the power of his home country in which he retained his domicile. It is consistent with the early American law of state and national citizenship, which turned on domicile. It overrules Dred Scott because it restores the rule of decision under which Scott should have won, namely that he was entitled to sue as a citizen of Missouri because he had a permanent domicile in the state. It excludes tribal Indians because they remained first and foremost subject to their separate nations, which alone had complete jurisdiction over them. And it ensures that the freedmen who were clearly American would not be denied citizenship based on a racial caste system. In other words, the phrase subject to the jurisdiction meant that the drafters and ratifiers said that it meant complete jurisdiction. fully and completely subject to the jurisdiction of the United States, the jurisdiction of the United States in every sense, and a full and complete jurisdiction coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department, that is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now. The phrase thus also had the implication that the drafters and ratifiers said that it had the children of temporary visitors were not citizens. The citizenship clause, they said, would not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers. After all, we would have no right to make citizens of persons temporarily resident in the United States. The court's alternative theory is more difficult to square with the text. The court defines the phrase subject to the jurisdiction of the United States to refer to the power of the United States to govern those within its territory. It then says at least three categories of persons born within the United States territory are not subject to its jurisdiction. First, a person is not subject to the jurisdiction of the United States when the government impliedly waives its regulatory power over him. The court understands this category to exempt all children of representatives of foreign sovereigns, endeavoring to capture a long-standing principle that such children were not entitled to citizenship. Although the court gestures toward diplomatic immunity as a basis for this exception, diplomatic immunity extends to only a narrow set of diplomatic officials, not to all foreign representatives. Most foreign officials receive a partial immunity, such as immunity for their official acts. But partial immunity cannot render a person not subject to the jurisdiction of the United States for 14th Amendment purposes. After all, a variety of clearly American government officials, such as judges, prosecutors, and police officers, have similar partial official immunity. Furthermore, if the political branches can deny someone citizenship by waiving their regulatory power over him, then they can deny citizenship to any child in America, even if his family has lived here for generations and has no other home. The better explanation for excluding the children of foreign representatives is that they were not domiciled in the United States. Second, the court says a person is not subject to the jurisdiction of the United States when the government lacks actual power over him. This category presumably is an attempt to accommodate the consensus that citizenship would not have been granted to the children of foreign invaders. See the respondent's brief, recognizing exception for a person in an occupying army. See also Sotomayor dissenting in Casa, recognizing exception for a person born of alien enemies in hostile occupation. But while the child of a foreign invader is of course not constitutionally entitled to citizenship, it is not because America lacks actual power over him. If it were, then citizenship could be denied to any American over whom the government happened to lack actual power at birth. The more likely reason why foreign invaders are not citizens is that they too are foreign and not domiciled here. Third, the court says, a person is not subject to the jurisdiction of the United States when he is a member of an alien and sovereign nation. This category reflects the court's attempt to accommodate the historical record that the Citizenship Clause excluded the children of Indians in tribes. But the court cannot explain why tribal Indians were not subject to the jurisdiction of the United States if they happened to be born outside Indian lands, while foreign temporary visitors were. It is true that tribal Indians belong to alien and sovereign nations, and that the United States' relations with them implicated inter-sovereign concerns. But temporarily visiting foreigners also belong to alien and foreign. Yeah. But temporarily visiting foreigners also belong to alien and sovereign nations, and the United States' relations with them also implicate inter-sovereign concerns. It is difficult to understand why China, for example, would be less alien or less sovereign than the Cherokee nations. It is also difficult to understand why tribal Indians would be less entitled to American citizenship if born on non-Indian land within the United States than children of birth tourists who immediately return to China. So we'll stop there for today, and I'll wrap this up tomorrow. And as always, if there's any case you'd like me to read, just drop in the comments, and I'm happy to take a look. Thank you.